Good afternoon, good morning to those calling in from the US, and welcome to this webinar about what Brexit will mean for IP rights from a UK point of view. My name is Mark Owen, and I'm a partner in the IP group at Taylor Wessing. And with me I've got several of my colleagues who are all going to talk about different aspects of IP rights. Chris Benson, who's going to talk about trademarks, Jason Rawkins, who's going to talk about designs, Paul England, who'll talk about patents, and Joe Joyce, who'll talk about trade secrets, and I'll talk about copyright. The format of today is that we'll hopefully talk for a little less than an hour. We're going to try to cover a lot in that time, and since we are trying to cover all of the main IP rights, you may find that your favourite IP right gets less discussion than you may want, but please do feel free to zone in and out depending upon when your slot is. The order will be trademarks, designs, patents, trade secrets and copyright, about 10 minutes each. You might find it, however, useful to listen across all of the rights, because what we're finding is that some of the questions which arise apply right across whichever kind of IP right you're interested in, but may become more obvious or come about more quickly on one right than another, but eventually they may well apply to all of them. So it may be useful for this at least to have an overview of all of them. So I'm briefly going to introduce the topic and where we are with IP rights and where we're going to go to. So really as a refresher for how European law applies to IP rights, pretty much all of UK IP law derives or is affected by, in one way or another, EU law. And virtually all of the lawyers acting in the field in the UK and virtually all of the judges have practiced their entire careers, or most of their careers, as EU IP lawyers. IP is one of the fields which is most connected to EU law, and so the prospects of disentangling this from EU law for the UK raise some very fundamental and large issues. Just to give you a quick overview, the various sources of EU law, most of the ones which apply to UK IP laws are in the form of EU directives. So that's where the EU says this is what the law should be, and each member state implements it in its own way. And as I say, much of the EU IP law in the UK is implemented by means of directives. Then there are what's called regulations, where the EU says this is the law, and that takes direct effect in the member state without there being any need to have a specific law about it. And so, for example, where there are EU harmonised rights such as the EU trademark, that has been brought about by direct effect regulations. And then probably the third most important source of law is case law coming from the EU courts. The most important of those is the Court of Justice in Luxembourg, and those decisions apply to courts which are all have to follow them in the UK as they do in other member states. Decisions of the other EU court, the EU General Court, are also adhered to, or the reasoning is followed, and increasingly we look at the courts of other member states, particularly the courts of appeal and the Supreme Courts, when they are interpreting IP laws with an EU prism. So EU law affects pretty much everything we do. How it does it, though, varies. So there is no single IP right there's no single pan-EU IP right. There's a different regime for trademarks, different regime for copyright, completely different regime to patents, which perhaps has least to do with the EU framework. As a result of this, there are certain types of rights which people only really bother with on a pan-EU level now. So, as we'll hear about trademarks and designs, most applications for protection now, for registration, are done for a pan-EU right, not simply for a UK national right, and that may well change. And then the final source of law which will continue to apply whatever is all the various international conventions and agreements which have applied and are continuing to be developed for IP law internationally. So the Berne Convention, TRIPS, the various WIPO treaties, Paris, Madrid Convention, Protocol, etc. So there's a lot of law which comes in internationally, which is unlikely to change because of what we're doing. Don Rumsfeld, the infamous American politician, when asked to describe how things were going on in the Iraq War, when that was going on, described the situation as being that there being known knowns, known unknowns, and unknown unknowns, by which he meant that there were things we knew we didn't know, and things we didn't know we didn't know. And on the morning after the Brexit vote, on June the 24th, I think all of us felt that we were in the world of unknown unknowns, including all of the people whose idea it was for Brexit to take place. There was no plan that anyone had communicated, and no one had any idea what was likely to happen. Nearly 4 weeks on from there, we are seeing the shape of how things may be, although the big issues have still not provided any answers, such as what shape of future deal we'll have with the EU. But what we're going to try to do today is at least move some of the unknown unknowns into the known unknown columns. But the big issues which apply to IP rights include, well, what's going to happen to these ones which apply right across the EU? Are you going to end up with a system where you have EU 27 rights applying to remaining member states and a separate UK right? And if you've already got a EU right, will that somehow convert into a new UK right? And will rights applied for at a particular date be treated differently to ones applied for after that date? We wait to see. What's going to happen about all of the English law, which, as I said earlier, has derived from EU law? What's going to happen to all of the statutes which have been based upon directives? Will those statutes remain the same? And what's going to happen to all the law relating to them? Will we continue somehow to follow how that law develops at an EU level, or will we develop our own UK version of it, following just our own Supreme Court and courts here? And will it be possible to challenge decisions but based upon European laws which no longer apply? The biggest issue, I suppose, facing everyone at the moment is, well, what's the new model going to be? And there's been lots of suggestions as to what form of relationship the UK can have with its largest trading partner, in the form of the EU. The one that most people talk about is being part of the European Free Trade Association and member of the European Economic Area, which may well leave things pretty much as they are. But are there other models? That is yet to be seen, and so far there's very little clarity from any of the politicians. The only thing we know so far is that it's going to be at least 2.5 years before we get to the point where we split. The government said yesterday, or day before yesterday in court proceedings here, that it would not seek to invoke Article 50, which is the mechanism which kicks off the 2 years of leaving the EU until 2017. So we know we've got another 6 months at least before that starts. And finally, before passing on to my colleagues, even if the leading politicians haven't said anything about IP and where it may take us all, it may be useful looking at some of the things that have been written by people who were in favour of Brexit before it took place. And what I put there are some words from the website of an organisation of some lawyers who are in favour of Brexit called Lawyers for Britain, and I've just highlighted 2 parts of that. It's an interesting read, all of it. And first they talk about what may happen to existing EU laws, and they say where EU-derived laws are enforced which are not actively harmful, there would probably be even presumption in favour of keeping the substance of them enforced for the time being, which, like all simple statements, sounds sensible. But when you dig down, you wonder where that actually leaves us. And further down on the page, they do actually talk about some elements of IP laws, and that may be because one of the leading lights in this organisation is one of our leading IP QCs. And there they talk about what may happen with Brexit to IP laws, and so it seems very much pro-user and anti-rights then. It talks about extending exemptions, presumably or exceptions to copyright, restricting scope and term of protection that confer no economic benefits, simplifying areas of law, and liberalising our parallel imports regime so that parallel imports which would currently not be permitted would be permitted. And going back to their point about laws which are not actively harmful, the issue really is going to be that although some people see the benefit in liberalisation along those lines, others see that as it being a retrograde step which is going to harm rights owners. There are going to be plenty of battles to come, and probably the best advice to everyone at the moment is to keep engaged and to keep lobbying for whatever your point of view is. At that point, I'm going to pass over to my colleague Chris Benson, who's going to talk about trademarks.
Thanks, Mark. Good afternoon, everyone. Yes, I'm going to look at trademarks. I'm going to look at the impact of Brexit on existing registered trademarks and on unregistered trademarks. Then I want to consider how trademark law in the future could develop in the UK if we are no longer part of the EU, how Brexit may affect trademark litigation, and finally some practical steps. So firstly, looking at EU registered trademarks, well, I think the first thing to stress is that it's going to be business as usual, as Mark said, for at least 2 years. The UK will remain part of the EU trademark system and continue filing EU trademark applications. The big question, of course, is what happens to EU trademarks when the UK leaves the system. And the 3 possibilities we've come up with. Firstly, the UK could remain part of the EU trademark system. Secondly, the UK protection would immediately lapse. Or thirdly, which is the one which is favoured, is there's going to be some kind of conversion process where you would have split rights, you would have an EU trademark, and you could apply to the UK Trademark Office for a UK national mark, which would hopefully keep the same priority and have the same filing date as the EU mark. Now, some questions here. Are you going to have to pay an official fee for doing that? And probably yes, because it looks like there would be hundreds of thousands of EU trademarks which would need to be converted into UK marks. And another question is, could the UK Trademark Office cope with such a big influx of work? Another question is, if you have an EU registered trademark and you do convert to a UK mark, will that mark have to be examined again by the UK office? Or hopefully, if it was registered in the EU, it can become automatically a UK registered trademark. So those are some of the issues which need to be ironed out if we go down this conversion process. One thing I did want to mention is that trademark owners should, however, look at their EU registrations which are over 5 years old and therefore could be revoked for non-use. And there are 2 situations here. You could have an EU mark which you haven't used in the UK, but you've used in other parts of the EU, or you could have an EU mark which you've only used in the UK and you haven't used anywhere else. Now the question then arises, if you convert that mark into an EU mark and a UK mark, and one of those in these circumstances will be immediately revocable for non-use. So if you've got the mark that hasn't been used in the UK but being used elsewhere, the UK mark is revocable. Or if you've got the mark that's only being used in the UK and not in the rest of the EU mark will be revocable for non-use. So hopefully there will be some legislation which says perhaps that the use that's been made throughout the EU would be deemed to be use of these split marks. That again is waiting to be determined. A quick point about international registrations. Well, firstly, for the UK designation of an international mark, basically Brexit will have no effect on that because that UK designation is treated in exactly the same way as a UK registration, so no effect on that. But a point to be aware of is if you have built a Madrid filing system based on an EU trademark, which because of the difficulties we often don't advise clients to do, but if you've done that, of course you've got a UK company has applied for the EU mark, got it registered, and then applied for the Madrid mark and said it had a place of business in the EU, for example, a factory in the UK. What then happens if the UK leaves, if you've got no place of business in the EU, apart from the UK, which is no longer covered? What happens to your Madrid marks? Again, something else, it's unclear what the effect of that would be and the effect on your international marks. Finally, on this point, a bit about seniority. As you probably all know, you can claim seniority for an EU mark from an existing UK mark if the mark is the same, the owner is the same, and the goods and services are the same. So you can let your UK registration lapse and claim seniority so that your EU mark, the UK part of it, is deemed protected from the date of the UK registration. We would advise at this stage that clients do not consider claiming seniority or allowing any UK registrations to lapse until the position is clear about what's going to happen in the future. Unregistered rights. Well, basically, passing off an unfair competition, these are not affected by Brexit. These are purely national rights, and so those will continue in the same way as they do now. Point to be aware of course, is that if you do have UK passing off rights, in future it's unlikely you'll be allowed to rely on those to oppose an EU trademark application, as the UK will not be part of the EU system. So those passing off rights won't assist you in opposing an EU application. What about .eu domain names? And similar to the Madrid system really, to own an EU domain name, the owner has to have basically a place of business in the EU. What will happen when we leave? Again, we don't know. Again, what will happen to the existing EU domain names? Will they still remain in force? Something else to be considered. Turning to how UK trademark law could develop in the future, and coming back to something that Mark said, that in time English judges will be making their own decisions on trademark law. They won't be bound by decisions of the Court of Justice. So we will end up in a few years' time where the trademark law in the UK could be different from the trademark law in the rest of Europe. So we could have different tests on what is registrable as a trademark. We could have different tests on what is an infringement of a trademark. And as some of you probably know from reading some of the judgments in the UK, there are some UK judges who are known not to be fans of the judgments coming out of the EU system. So there are some areas where they will be chomping at the bit to get their teeth in and making new law. And just to mention a couple of areas where there could be divergence in the future. Firstly, the non-traditional marks, where you have to show acquired distinctiveness in order to get a registration, such as the famous Kit Kat bar, which has been the subject of a number of cases. Now, in the EU, it is easier to get registration for those types of marks if you show, for example, sales figures, advertising figures, and market recognition, consumer surveys. Conversely, however, in the UK, it is harder to get those registrations because there's an extra test which has been introduced by the UK judges that consumers actually have to rely on a shape before it can be accepted as a trade origin. Will it in future be harder then to get those shapes and other types of marks registrable in the UK? Possibly. Another area where the trademark law may diverge is in connection with the less distinctive marks, the weaker marks, what are called the fig leaf marks, where you apply to register what could be seen as a descriptive mark with a logo and get a registration. And there is a famous case in the EU where a party applied to register Alpine with a logo for ski clothing, got a registration, and has used it successfully to stop another party registering a mark for Alpine, again descriptive for ski clothing, with another logo. That is a symptom of the cases which are being decided by the EU IPO, where they do give wide protection to these less distinctive marks. In contrast, however, in the UK do not like this extra protection. So, for example, in the Now case, the Now was registered with a particular logo, but it could not be used to stop somebody else using the mark Now for television services. So are we going to find in the UK that these types of marks have narrower protection? And possibly that is correct, that they should have a narrower protection because they've only been allowed to go through to registration on the grounds that they've got a distinctive logo with them. Looking at disputes, some points to bear in mind here. An upside for claimants if they're going to bring an action in the UK in the future At present, if you want to take action against a third party claiming they're infringing their EU trademark, that third party could apply to the EU IPO that your mark, for example, could be revoked for non-use or is invalid, and these decisions can take 3 to 4 years before there's a final decision of the Court of Justice, slowing down the case of litigation. That will no longer presumably be possible when we can no longer make references to the CJEU. So that's an upside for claimants who want to bring an action for trademark infringement in the UK based on their UK rights. On the other hand, there's going to be downsides for defendants who are based in the UK but not the rest of the EU. If they're faced with a claim for a pan-European injunction because they're infringing an EU registration, the rules at the moment say the claim has to be brought in the courts of the country in the EU where the defendant is based, and if it's not based in the EU, in the courts of the country where the claimant is based, and if neither are based in the EU, in Alicante in Spain. So the moment a UK defendant who faces a claim for pan-European injunction can ask for the case to be brought in the UK. In future, if it no longer has a place of business anywhere else in the EU, it's going to have to face the possibility that it could have action taken against it in the court where the claimant is based, be it Malta, be it Latvia, be it Croatia. Or if not, if neither of the parties, it may have to face an action in Alicante in Spain. Going back to my point about diverging case law, it could also be the case that in future we're going to have different decisions from different member states because there are different laws. So a claimant may bring an action against a defendant in the UK for infringement and succeed, may bring an action on exactly the same facts in Germany, but not succeed because of the differences in law. And finally, on exhaustion, as you probably know at present, the rights and registered trademarks are exhausted if the trademark owner consents to the goods being placed on the market in the EEA, and then he can't stop any further dealings with them. How will that work out in the future when the UK is no longer part of the EU or the EEA? Is it going to be the case that the rights are going to be exhausted when they're placed on the market anywhere in the world, and the UK owner cannot stop them then coming into the UK? Or are we going to have a fortress UK position where the rights are only going to be exhausted if they're first put on the market in the UK? Again, that's probably going to be a political decision, but I imagine there's going to be quite a lot of lobbying going on about what the position will be there. And finally, practical steps. As I mentioned right at the start, it's business as usual. So parties should continue to file EUTMs until we leave the EU, and it's better to wait the outcome of what happens to Brexit rather than comprehensively refiling all of your EUTMs as UK trademarks now. However, going back to my point about the revocation of old, over 5 years old registrations, look at your portfolios, look at your European trademarks that are only used in the UK or outside the UK. If you're only using an EUTM in the UK, can you extend it genuinely to use in other countries so that you can save the registration outside the UK? If you're only using outside the UK, it may well be that you should now consider filing a new UK trademark application because conversion may not help you. Also look at your portfolio. Do you regularly rely on any UK national marks in oppositions to block third-party EUTM applications? If you do, because you won't be able to use those UK trademarks in the future, and you won't, as I mentioned, be able to rely on passing off, consider filing now a new European Union trademark application which you can use as a basis of an opposition. And or consider filing a national mark outside the UK, such as a French or German mark, to use as a basis of opposition. And my very final point relates to revocation. At present, if you're faced with a revocation action and you're asked to provide evidence of use, what most parties do is gather together all their details of sales and advertising throughout the EU and use those as evidence to show that they have been using their using their EUTM mark. Now, of course, when we do leave the EU, we're going to have to consider putting together separately all the UK sales and advertising figures. The sales in the rest of the EU are not going to be relevant, and so you're going to need to keep separate files showing advertising, showing sales, showing market surveys, showing consumer recognition just for the UK market. And with that, thank you, and I will hand over to Jason Watkins, who will talk about designs.
Thank you very much, Chris. One thing worth mentioning, I think, before I continue is that if anyone's got any questions that are occurring to them as we're going through, from the screen that you're on, you can submit those to us. And if we've got time during this or at the end, we'll do our best to pick up on those. So please do feel free to do that. So I'm going to give you a quick whistle-stop tour of how the world of designs is likely to be impacted by Brexit. As with all of this, there's quite a few unknowns. We'll try and make them into known unknowns, and at least give you some food for thought as to the direction of travel that we see and practical steps you might be thinking about taking. So very briefly, the current landscape before Brexit is we've got 4 different types of design rights in the UK. We've got EU-wide registered designs. We've got the EU-wide unregistered design right, which has proved very popular with IP owners for which designs are common, for example, in the fashion industry. Then UK only, we have our own directly equivalent UK registered designs, the same as EU ones, but of course limited to the UK. So the design equivalent of the trademark position, where you obviously have in parallel EU trademarks and separately UK national ones. And then finally, a right that I guess often almost gets forgotten about, and people were lobbying to repeal not that long ago. Now perhaps we're happy that it wasn't. We have our own form of UK-specific unregistered design right, which is completely different from the EU version and supplemental to it at the moment. The positive side of that is that it lasts for 10 years rather than 3, but the negative side is that it's much more narrow in terms of what it protects. So typically it will protect 3-dimensional articles, that's what it's aimed at, but not therefore the surface decoration that may appear on the outside. So for example, it will cover the shape of a handbag, but it won't cover the pattern or colours that may appear on the outside of that handbag, which may also be important. That's where we are now. What's going to happen after Brexit then? Well, looking first at existing and EU rights. EU registered designs, obviously at the moment covering the whole of the EU. When we cease to be part of the EU, then logically they're not going to apply in the UK anymore, not automatically anyway. The expectation is, but again it's a bit of a known unknown, is that there will be the possibility of converting that in the same way as Chris was talking about in relation to EU trademarks. In other words, you convert your existing EU registered design so that you have your current one but without the UK, and separately you pay a fee and apply to the UK IPO and get a UK equivalent of it with the same priority date as the original EU one. That's probably what will happen. It would seem a sensible way to go forward. What about existing UK rights then? Well, registered designs, they're not going to change. There's no qualification issue for that. Anyone can own a UK registered design, so if one exists already, that's going to stay exactly the same. UK unregistered design right, I mean, on the face of it, there is no change because it's a UK right, but there is potentially a qualification issue here because, as some of you will know, you don't get UK unregistered design rights no matter where you're based in the world. It's only if you're in the UK, or there's a couple of other countries we have bilateral arrangements with. I think one of them is Hong Kong, or by dint of being in the European Union, any European Union company or person qualifies as well. So for example, at the moment, if you're a French company that came up with a design, you would qualify for UK unregistered design rights in the UK, of course. But what's going to happen to that when we're no longer part of the same organisation, we're no longer in the EU? Will that unregistered design right belonging to the French company continue, or will it come to an end? I mean, you would think that given that it was qualification at the time when it came about, that it would just continue for the remainder of its term, a bit like, you know, if you're a French national living in the UK at the moment, you're going to be, one would think, allowed to stay, although no one knows yet. It's another known unknown, but a point to be aware of anyway. Okay, practical steps now in terms of what you may be thinking about you should do. And again, looking first of all at existing EU rights. What should you do there? So let's assume you've got an existing EU registered design. As I mentioned earlier, most likely you're going to be able to convert that at a later point, in which case you'll end up with a UK equivalent as long as you're willing to pay the fee and do that. Is there anything you could be doing if you wanted to play it completely safe? Because no one knows that's what's going to happen. It's just what people think is a logical thing to do. With trademarks, you could, because there would be nothing stopping you filing a UK trademark now, if you wanted to play it safe. With designs, it's a little bit different because, as you will probably know, there's a novelty requirement for designs. So you'll only be able to get a design through to registration if it's original and new at the time of its application. So if you've got an existing EU one, by definition it's already out there in the public domain, and if you subsequently apply in the UK, you'll have destroyed your own novelty in relation to that design. So unless your EU design registration is less than 12 months old, in which case you can take advantage of the 12-month grace period you're allowed, then you're not going to be able to get a UK equivalent anyway. In terms of existing EU unregistered design right, being an unregistered right, there's not really anything you can do. Of course, you may separately have the UK unregistered design right, the UK specific version we were thinking about, if it's the kind of design that qualifies for that. What about new designs then? So we've talked about ones that may be existing. What about new ones that come up either now, in the next 2 years or so before we depart out of the European Union, or perhaps after that? From a registration point of view, I mean, not all companies will go for design registrations for everything because of the cost that's involved. It depends on the case-by-case business whether you typically do that. If it's one where you do normally apply for registration, then for new designs, probably the sensible approach is to carry on as normal for now, apply for an EU registered design on the basis that it's highly likely you're going to be able to convert it later and get a UK equivalent to fill the gap once we're no longer part of the EU. If you don't want to take that chance, because we're talking here about new designs coming up and not ones that are already out there, you could adopt the belts and braces approach, and at the same time as filing an EU design registration, also file one in the UK, especially because it's very cheap and cheerful to do so in the UK, a few £100 cheaper than getting a trademark through. So it may be that if it's important enough, it's worth taking that cautious approach. Lastly then, so again on new designs, but looking at the unregistered design rights, so the kind of situation where you wouldn't normally bother going for registrations, there's a difference here to be aware of between if you're a UK company and if you're not. So if you're a UK company, with new designs that come up, you're automatically going to get EU unregistered design rights for the remaining part of the EU, but not the UK. So that will carry on. There's no qualification issue for EU unregistered design right. You don't have to be an EU-based company. Anyone qualifies for it in terms, as long as it's put on the market and made available in the EU. So that will remain for everywhere else. If it's within the scope of our current form of UK unregistered design right, then you'll get design rights here as well. But if it's surface decoration, and I mentioned at the beginning, which doesn't come under our UK-specific form of unregistered design right, previously it was covered by, or is covered by EU unregistered design right, including in the UK. But when we cease to be in the EU, that will no longer apply. So if it's surface decoration and you want UK protection, then what you should do is file for a UK design registration instead. A cheap and cheerful process, as I was mentioning earlier, and a way of filling that gap. Finally then, you're a non-UK company in this situation. Again, you'll get your automatic EU unregistered design right. No qualification issue for that, but it won't give you any coverage in the UK if it's later on when we're no longer part of that. So how do you cover the UK? Well, you could rely on UK unregistered design right, but we've already identified there's a potential issue there in terms of qualification. So your safest bet, I think, if you're in that situation to cover the UK, is definitely to file for a UK registered design, whether or not it's a surface decoration point, just as a general point, because otherwise you could fall foul of the qualification criterion. So a lot of ground in a short space of time. I hope that's been of some use, and do feel free to put questions up or reread the slides later. Thank you. I'll hand you over to Paul on patents is next, I think.
Thanks very much, Jason. Yes, patents can be, I think, fairly or relatively briefly dealt with in this presentation, because there are essentially two sides to it. Firstly, there's how does Brexit affect the current patent system in Europe, and there's also the question of how does Brexit affect the system that we were, as I shall explain, about to have. Just dealing on this first slide with the present system. Well, the simple answer, as Mark alluded to earlier, is that Brexit really doesn't affect the present patent system very much at all. The European patent system is governed by the European Patent Convention, known in shorthand the EPC. And the EPC is an intergovernmental agreement which is completely independent of the EU. In fact, has 38 contracting states, which include the EU's 28, but it's not limited to them. And the decisions that are made by the European Patent Office to grant patents and in the opposition and appeal of the validity of European patents are made completely independently of the Court of Justice of the European Union. So all of that will continue. And what that means in terms of grant is that the system of patent grant through the EPO, whereby a single application is made centrally to the EPO in Munich or one of its other offices, that upon grant that application breaks out into a bundle, what we call a bundle of national rights, each of which patent right is valid for a national territory alone. So the consequence of that is disputes are still going to be heard in the national courts of the country for which the patent is designated. In the UK or in England and Wales, that means the Patents Court or the Intellectual Property Enterprise Court. And also, as I said, oppositions and appeals in the EPO on patents, oppositions which are filed within 9 months of grant will also continue. The only area where there may be some disruption due to Brexit is on those cross-border decisions, which are not in themselves very common, whereby one country, due to the Brussels regulation, which is a piece of European Union jurisdictional legislation, can be decided across border. As I say, they don't happen very often, but there may be questions raised once the UK is no longer part of Brussels, if it's not also part of Lugano, which is a similar convention for the EFTA states, which reflects the terms of Brussels. If it's not a member of that either, there may be complications in enforcement of cross-border judgments. And indeed, Mr. Justice Arnold essentially invented last year a new kind of cross-border declaration of non-infringement of foreign patents that is heard and awarded in the UK courts. And that may similarly be affected in those cases where those kinds of awards are given. The one other area, which is only relevant to pharmaceutical companies, is supplementary protection certificates, SPCs, which are a right of up to 5 years additional protection for a specific pharmaceutical product, in addition to any patent protection underlying it. Because they're based on an EU regulation, that regulation, by the time the UK exits the EU, that regulation will have to be replaced by UK legislation. But indeed, that may actually, the SPC regulation being a piece of legislation that's been criticised very heavily over the years, that may actually be an opportunity for the UK to improve upon SPCs. So the real question is what happens in future. Next year, before the Brexit decision, we were expecting next year in May or June or July the Unified Patent Court and Unitary Patent to come into force. Now, this is a project that has been in the making for some 40 years in various forms. The Unified Patent Court, the UPC as it's known, is a pan-European court, a truly pan-European court that was to cover 25 member states. And what that meant was that European patents, and indeed the new unitary pan-European unitary patent, could be litigated in one set of proceedings, and in one decision it could either be revoked or enforced in all of those countries simultaneously. It's an extremely powerful proposition for patent owners and indeed third parties who are trying to clear away patents. So what happens to that now? Well, it's key that the UK was one of the countries whose ratification of the UPC and the unitary patent was obligatory before it could enter into force. And the UK ratification was expected later this year. So what happens now? Well, in the table that you can see on this slide, there are, very broadly speaking, 3 possible scenarios where we go from here and what the effect of this ratification or non-ratification is. Firstly, in the first line, if the UK does ratify, then the court can still, if Germany also still ratifies, the court could come into operation next year. Is that likely to happen? It seems unlikely from a political point of view, because one could ask, why would the UK government ratify the UPC agreement, which is ultimately subject to Court of Justice law, and why would it ratify the unitary patent, which is itself an EU instrument, given that we've just had a decision by UK population to leave the EU? It seems unlikely. The second scenario is that there is no ratification and then the UK somehow manages to strike a deal as part of the general exit negotiations for the EU to remain part of the UPC, even though it's not an EU member state. Alternatively, we could not ratify, and during negotiations it becomes clear that the UK can't participate in the UPC. In either of those cases, the UK doesn't ratify, the delay is going to go on, it seems, until all of these decisions come out in the wash, so to speak, at the end of the exit negotiation, which current predictions would suggest is not going to happen until 2019, 2020. So for the EPC it means delay. So will the UK remain part of the EPC? Let's just look at that in a little bit more detail. Back in 2011, when being asked to provide an opinion on a previous incarnation of the UPC, the Court of Justice, in a decision which was essentially about the power of a central court to refer decisions to the Court of Justice, and the degree to which member states would then still be on the hook for infringement of EU law, had been understood and interpreted by the Commission to mean that participants in the UPC and the unitary patent had to be members of the European Union. Well, as soon as the Brexit vote was known, academic opinions were circulating that the UK could still participate in the UPC and unitary patent even though it wouldn't be an EU member state. Whatever the rights and wrongs of those opinions, and there are further opinions circulating and yet more opinions being prepared, there still is a political problem, which is that it would require the UK ultimately to sign up to a European instrument in the form of a unitary patent, and the possibility of CJEU law decisions, rulings affecting the UPC decisions and therefore affecting the UK. So it's still a political problem. But what is clear from a Munich conference 2 Thursdays ago is that those who are in charge of preparing the patent in the court have said that they are very keen for the UK to participate in it. They see that as the best case scenario, but they are still prepared to go ahead with the preparation of the UPC and the unitary patent, even though it's a worst case scenario without the UK in it. So finally, one could ask, will users still want a UPC and a unitary patent without the UK? Our GIPI 5 survey indicated, before the Brexit decision was known, that confidence in the UPC as a forum for enforcing patents and confidence in the UPC as a forum for revoking patents was roughly around the area of 6 out of 10, which may seem fairly lukewarm, but against the background of many years where a great many people have been very critical of this system and very concerned about the quality of judgments that it would deliver, that is actually quite a good result. Will it be maintained in a UPC without the UK? Well, it's important to remember that UPC, even without the UK, still covers 24 member states, including Germany, which is the largest economy in Europe, so it's still very significant and still a very attractive proposition. And what would be likely to happen if the UK were not a member of it would be that the UK would maintain a strategic role in revocation and declaration of non-infringement decisions, which would be used side by side with the UPC jurisdiction. But this all remains to be seen over the next 2 or 3 years. Now handing over to Jo.
Thank you very much, Paul. The good news is I expect to be even quicker than that, because it's more or less business as usual as regards trade secrets and confidential information. As most people will be aware, the protection of those types of quasi-IP rights is all done on the basis of common law in this country, and doesn't even exist at all in lots of other jurisdictions. However, that said, we are about to see a little bit of a change in the European horizon when it comes to trade secrets in particular. We have a new European directive on the protection of undisclosed know-how and business information, i.e. trade secrets, protecting against its unlawful acquisition, use and disclosure. It's been on the cards for some time, and with all the Brexit furore, you would be forgiven for not having noticed that this directive has now been adopted. It sets out the rules and requirements for member states to protect trade secrets, and it's expected to be implemented Europe-wide by June of 2018. It will require member states to ensure that those who lawfully control trade secrets, imaginatively named trade secret holders in Directive, ensure that they can obtain redress for any unlawful acquisition, use or disclosure of their trade secrets, and that's Article 1 of the Directive. Now, it may surprise a lot of people to learn that in a significant number of member states there isn't any protection, or there's negligible protection for trade secrets at present, whereas we're in a far more favourable position in the United Kingdom. Article 2 of the new directive defines a trade secret as information that meets three conditions. It should be secret, in the sense it's not generally known amongst or readily accessible to persons who normally deal with that kind of information. It must have commercial value because it is secret, and the trade secret holder must have taken reasonable steps to keep the information secret. That definition may sound relatively familiar to people who are used to dealing with confidential information in the United Kingdom. Aside from the requirement to have commercial value, it mirrors fairly closely the tests that we apply to protecting confidential information, which I'll come on to in a moment. The good news for everyone here is that we're already compliant with the new directive. The House of Commons European Scrutiny Committee reviewed the proposed directive in 2014 and found that our common law provisions, that's our body of case law that protects confidential information in the UK, was already significantly ahead of most other European countries, and would mean that we would already be in compliance with the directive. But the only difference at that stage was that the directive was proposing a shorter 2-year limitation period for bringing claims arising from its breach, whereas in fact we have a 6-year limitation period in the United Kingdom. However, they obviously listened to our points on that, because in fact the directive as passed has a 6-year limitation period, so there's really no area in which we diverge significantly. In fact, confidential information is protected in the United Kingdom in a much more broad fashion than merely trade secrets. Trade secrets are a form of confidential information, but in fact we protect all sorts of information that has the necessary quality of confidence. I always like to refer back to the Coco and Clark definition, because even though it's 1968, it's still extremely good law, and looking at that will remind you of the test we just saw, what qualifies as a trade secret under the new directive. Now, of course, we protect information that is secret and has more than merely commercial value within the United Kingdom, and the basis for a lot of our privacy claims, the sort of celebrity claims that get so much more attention in the media than trade secrets type litigation, the basis of those claims is exactly the same as the claims that are protecting trade secrets within this jurisdiction. And a lot of people have thought that actually the types of privacy claims that we've seen develop in recent years would be significantly impacted by Brexit moves, because many people are under the mistaken operating under the mistaken notion that a removal of ourselves from the jurisdiction of the European Court of Justice is the same thing as removing us from the purview of the European Court of Human Rights. That is not the case. We are separately signed up to the European Convention on Human Rights and the jurisdiction of that court, and unless and until we also consider withdrawing ourselves from that particular arrangement, the requirements of Article 8 of Right to Privacy and Family Life and Article 10, which have been incorporated into UK legislation through the Human Rights Act, will continue to apply. So as you can see, there's not likely to be a significant change for us as a result of withdrawing from the EU when it comes to trade secrets protection, even to the extent that we withdraw before the actual coming into force of the directive. We wouldn't need to amend our legislation, or rather create statutory legislation, even if that weren't the case. Regardless, we are also going to be in a position to continue taking advantage of the newly increased rights to protection in other European member states, since trade secrets holders won't need to have any specific nationality qualification requirements. As long as you have a trade secret and your right is infringed in a European country, you will be able to enforce that right in that country, regardless of whether you're a UK national, a French national, or an American national. So good news all right there. What we might see, however, as a result of Brexit, and it's one of those things that it will be almost impossible for us to really determine and appreciate, is a change in the way in which the shiny new law on trade secrets actually develops in the European Union. Each member state will have to find their own way of implementing the requirements of the directive, and the European Court of Justice will have to find its own way on ruling whether or not those methods of implementation are sufficient, and whether trade secrets are given sufficient protection by individual member states. Without the Anglo-Saxon common law approach of the United Kingdom, on which a lot of this directive is quite clearly based, we may actually find a rather different method of interpretation and body of law in this area developing, quite separate from our own, but only time will tell on that. And that's me done, so without further ado, I'm going to pass you back to Mark Owen, who's going to conclude today's proceedings with some discussion of copyright and some of the broader issues in play.
Thanks very much, Jo, and well done everyone for staying with us this far. So as Jo said, I'm just going to go through copyright and how that may be affected. Copyright in the UK is very much a patchwork quilt in terms of how it reflects copyright law in other member states. Copyright law is one of those areas that is harmonised to some degree, and there is law both in the form of directives and in case law from the EU, but it does not apply to every aspect of copyright law, and it's very much a piecemeal movement towards a harmonised law. And the big question really is what will happen to where we are now when Brexit fully takes effect. Will we pretty much carry on as we are now, or will we continue with the direction of travel that the EU's been taking? And so what I'm going to do, I'm just going to briefly talk about where we are now, what that direction of travel looks like, and the issues which are going to come up in the very near future. So dealing first with, as I call it, the patchwork quilt, I've listed there some of the things which are harmonised across EU copyright law and some of the things which are not harmonised. And as you'll see, some things like exceptions, some of them are harmonised, some are not. Some are mandatory across all member states, some are voluntary, and each member state has implemented them and interprets them somewhat differently. But the basic framework, I suppose the most important elements, are largely harmonised, though you could say that to a large extent hasn't really changed the law we had before the EU. There have been some important differences, changes, particularly around the way digital rights have developed, but the basic way that copyright functions has not particularly been affected by EU law because it reflects much earlier treaties such as the Berne Convention and also more recently various WIPO copyright conventions. So one way of looking at this may be that actually we've got a framework, it's been affected to some extent by the EU, but perhaps not that greatly, and we could probably carry on with how we are now. I think the big issue though is going to be how things change, and importantly, particularly with digital rights, which rely very heavily on a borderless environment, what happens when we no longer have a say in how those rights develop at the EU level? So looking at the way our law is set at the moment, the basic act is, what's it, typo and patents there, the UK's Copyright Designs and Patents Act 1988, which has been amended in various ways since, and most of those amendments have come out of EU law. So for example, around databases, broadcast computer programs, duration, temporary copies, all sorts of things which have changed, but largely affecting specific areas of copyright law, and not so many which have been applied across the board. And each of those have been made by amendments to our law based upon EU laws. I'm not going to go through those in detail now, but if anyone wants to ask questions about it, then please do email in. The direction of travel has been moving very much towards an EU approach to copyright, particularly I'd say over the last 5 years or so. So the two basic things which have led to this change were the introduction of the Information Society Directive at the start of this millennium, and then the subsequent very important case of InfoPack from the Court of Justice. And following those two, a completely different approach, I think, has been taken to how English judges have looked at copyright law. And increasingly, you are seeing not only EU courts looking at copyright in a new way and coming out with all sorts of case law, but you're also seeing the English judges react differently. So, for example, looking at recent cases, Mr. Justice Arnold, one of our main IP judges, said that any pre-Information Society directed UK case law on exceptions should now be treated with caution. Judge Hakon in the Intellectual Property Enterprise Court said that House of Lords decisions, which have previously been our Supreme Court, as it was predecessor Supreme Court, were not binding as they were pre-InfoPack. And the Court of Appeal has also said that one of the fundamental tests of UK copyright law now has to follow InfoPack. So the judges have realised that EU law has to be EU law is affecting the way copyright law is looked at in the UK. The Court of Justice itself, the biggest single area of cases it deals with are IP cases, and the vast bulk of those are trademark. But increasingly, over the last 5 years, it's been dealing with copyright cases and making some important pronouncements, particularly around the digital rights. So there's a large movement, I'd say, across the board towards harmonisation. And this has been given added impetus by the legislature of the EU, which over the last 18 months has been pushing very hard its idea that as we have a physical single market in the EU, we should be moving towards a digital single market. And a lot of the digital single market proposals relate to copyright. So, for example, we've had proposals around portability of content, and we're having, or there are studies going on as to the role of platforms and their role in copyright protection and that sort of thing. So there's a lot going on. But how are we going to change? Given that we are moving, as I say, increasingly towards a pan-EU approach, and that EU law is important to the way we look at things, that may suddenly change. So the most obvious immediate effect, I think, may be what happens to the digital single market. The UK and its content industries and its tech industries have played a very important part in lobbying and contributing to debate about how that looks. Those voices almost immediately are becoming less listened to and less important, so we're going to have less influence on how that works out. But for content owners and platforms, how it works out is very important, and so people are going to need to continue to be engaged in what that looks like, and so that you don't end up with a system which may favour different approaches from the EU, which a UK voice may have changed. Things which may change as we move forward, so we may not get the digital single market in the UK, we may not end up with changes to the way we look at digital content and how that's protected, but we may come up with our own versions of it. So, for example, the safe harbours, which protect particularly platforms and intermediaries from how they deal with content, may be changed. It's likely, I would think, that they won't become very different to the way they are now, but if the EU, for example, moves towards a more restrictive view of what platforms and intermediaries' role is, we may find that we don't follow that or are forced to follow that in order to keep or as part of whatever deal we end up with the EU. There's been a wish for a while among certain parts of the EU for there to be a single EU copyright title. So in the same way you can have a single EU trademark, you can have a single EU copyright. That too will no longer now apply to the UK. And the UK was one of the, I suppose, on the sceptical side of whether that's a good idea. It may be that it's more likely now to happen. Private copying has been tried to be introduced now in the UK without success, and part of the reason why is because of the UK saying they didn't need to provide for fair compensation for rights owners based on EU law, on the other hand, said that they needed to do that. If we won't have EU law, then it may be that private copying without fair compensation re-emerges as an issue. Chris talked a little bit about what happens about parallel imports and exhaustion of rights, and will the UK either become a haven for parallel imports, or will it become a fortress? And exactly the same kind of issues could apply to copyright. And then perhaps one of the most interesting issues is, several years ago when he was still Prime Minister, David Cameron had a fantasy of setting up Silicon Valley in East London, and he said that one of the main reasons, ignoring the weather and the tax regime and everything else which may have affected it, so one of the main reasons for that was because we didn't have fair use and they had it in Silicon Valley as an approach to exceptions. And at the time he was told, well, you can't have that because EU law says you can't, you have to have the fair dealing approach that we have. But is it now possibly a chance for that to ride again as an idea if we're no longer tied to Europe? I think one thing that's important to remember that all along, even without the EU, we're still going to have membership of things like Berne, TRIPS and the WIPO treaties. And so I think many of the fundamental aspects of copyright law are very unlikely to change, but what we may not do is stay quite as harmonised to the EU. There are plenty of other good models of copyright law. The US has, and it has its critics, but there's all sorts of aspects of that which make it a perfectly serviceable copyright regime. It may well be that we move closer to that or to other systems. That was all I was going to say, and that was all we were going to cover today. And it has been a real canter because there's an awful lot to cover. We're very grateful to all of you for listening and for staying with us. This is our first talk, and it's still early days, and as we move forward we will be having more detailed analysis of what you should be doing about your contracts, how you should be looking at potential proceedings going forward, how the regime for jurisdiction, enforcement and those sorts of things is likely to change, and also drilling down into more specific talks on things like copyrights and trademarks and how that's likely to evolve as the landscape becomes clearer. At the moment we're all somewhat in the dark, and people who are listening may well hear things which may be of interest as well. And if you do hear of things or have views as to how things are likely to evolve, then whether you agree with us or not, we'd really like to hear from you, because at the moment all information is very valuable. So on that note, thank you and good afternoon.